All right, let's get started with that. And welcome, everyone. Good morning and welcome to our Executive Roundtable and Information Session on CPRA and Employee Privacy. This is part one of a two-part series. Today, we're going to be talking to our HR specialist and our data privacy officer. And then on January 6th, we'll be talking to a privacy attorney, Diana Ikatani. She's very well respected in this area, and our own Eric Kong, who will talk about some of the security related issues regarding these new privacy regulations. So without further ado, we are going to get started. Our agenda, we're going to do some really quick self-introductions. Then I'll tell you a little bit about Consilien. We'll jump right into our roundtable discussion. So this is a structured conversation with our guest speakers, and we want you to join in. So if you have any questions, please put them in the chat or in the Q&A. I have Jeff joining us, and Jeff is going to be monitoring that, and we're going to make sure that we're going to get to your questions. All right. So don't be shy. And then we will wrap up. All right. So again, my name is Krista Hollingsworth. I'm the Chief Revenue Officer for Consilien and your host. I am joined by Linda Duffy, who is the president and founder of Ethos Human Capital, and Barry Weber, who is the partner and co-founder of Assured SPC. He is our virtual data privacy officer and a Consilien strategic partner. So we work quite a bit with Barry and his team. So, but I'll let Linda and Barry talk a little bit about themselves. Linda, tell us a little bit about you and Ethos.
Sure. Thanks so much, Krista. And thanks for inviting me to join you today. Again, Linda Duffy with Ethos Human Capital Solutions. We're a full-service outsourced HR firm. So we work mostly with small businesses that don't need and don't want a full-time HR person. And so we provide everything from recruiting and training to general HR consulting on a daily basis. Thanks.
Great. And Barry?
I'm Barry Weber, a partner at Assured SPC, and we help organizations implement privacy programs from the beginning of data mapping all the way through governance and implementation of technology to be able to show that you're doing what you need to do, as well as track requests from consumers. We'll talk more about employee consumers a little bit later.
Great. Thank you. And thank you both for joining us. I'm really excited that you're here. All right. So not everybody on the call is a Consilien customer. So I thought I'd let you know a little bit about Consilien. We were founded in 2001. What makes us a little bit different than other managed security service providers is that everyone on our leadership team has enterprise experience. And so we bring that management methodology and that knowledge down market to help our small enterprise and middle market companies thrive, to be efficient and to be secure now and in the long run. So we're very proud that we have customers that have been with us for 18 years and maybe some from the very, very beginning. So we're very proud of that. We provide managed IT, managed security, managed compliance services, working with great partners like Barry. We also provide executive consulting services, managed security awareness training, and managed backup disaster recovery. So that's a little bit about Consilien. All right. And if everybody could please turn off make sure that you are on mute, I would greatly appreciate that. All right. So let's jump right into the discussion. And I am going to stop sharing my screen right now so we can get a really good view of our speakers. So Barry, let's start with you. What is the California Privacy Rights Act, CPRA, and how does it relate to CCPA? One of the reasons why I wanted to have this session in particular is because most of our customers are B2B. They haven't had to think about CCPA. It hasn't really been on their radar. But now with the law changing to CPRA, they are now having to be involved. So can you enlighten us on what that is?
Yeah, certainly. If you're aware of CCPA, it was primarily focused on B2C business consumers, and And CPRA, passed in November of 2020, is an extension. I think of it as an amendment to CCPA. So basically, it just changes and adds to the law governed by California. It specifically there's a lot of changes associated with CPRA that include more focus on not only rights of consumers, as well as expanding the definition of a consumer. So the CPRA expands the definition of consumer to be B2B consumers as well as employees.
Okay. And what are the thresholds? As I know earlier when we were having a discussion, Linda, you said that a lot of your customers don't meet the threshold. Some will. What are some of the thresholds, Barry, that our customers need?
To be covered, you have to be a for-profit organization in California, and either have revenue over 25 million, or collect the information of 100,000 consumers, and that includes employees now, although I don't know how very many people have 100,000 employees, and or B2B contacts. So it actually, the number is much larger, and that's actually been replicated across many states. So some organizations are covered by multiple privacy laws, and we help them navigate through all of the combined privacy regulations. But each one of them is focused on their consumers. So CPRA is focused on the consumers, employees, B2B contacts, as well as B2C consumers that live in California, regardless of where the company is located.
Okay. And so,
or they buy or sell 50,000 names and addresses, consumer information. You don't have to, there's no revenue limitation associated with that. If 50% of your revenue comes from buying and selling the information of individuals.
Okay. So just so we're clear, it's not 25 million and 100,000, and it's you have to meet one of the thresholds.
One of the three thresholds.
One of the other questions then that just occurred to me as you were talking is, what about when you say, B2B consumers, employees, does that include their CRM? So let's say that their sales and marketing department has a huge list of prospects. Would that fall under CCPA or CPRA?
It does. It does.
That's really
as well as the individuals in the middle, contractors.
Okay.
They're fundamentally treated as employees to the business as well.
Okay. So a lot of customers or a lot of organizations may fall into CPRA and not be aware of it.
It's certainly possible.
Okay. That's really good to know. And what about some of the fines, Barry? Can you talk a little bit about the fine? Because the reality is no one's going to comply with this unless there's So
there's some interesting things that have gone on in California with respect to fines, but in terms of the California Attorney General's office looking for issues of violations. But the fines for administrative statutory violations is between $2,500 and $7,500 per individual. If there's been a violation, the California uniquely has a personal right of action if there's a data breach. So there's a security component associated with this, that individuals can sue organizations if there's been a data breach, and that the fine associated with data breaches can be $750 or the actual harm done to the individual, which is actually pretty tough to prove.
Yeah. We'll talk more about that, I think, in the security session in January. Linda, so how do you envision CPRA impacting the hiring and managing the employee process? How do you see this impacting employers?
Yeah, I think they're going to have to go through every step of their process in terms of the touch points with employees, and then sort of drill down in each section to figure out, what information are they actually collecting that's personal information? How are they storing it? Under what circumstances would they be sharing it with other people? Things like that. So if you think through the lifeline of an employee, you've got the recruiting portion, you've got them filling out an application, you've got them onboarding, filling out additional paperwork there. You're going to put them in the payroll system. You're going to provide them with benefits. So they've got medical benefits and 401k. It goes on throughout all the way up to and including termination and even COBRA notices beyond that. And so each one of those steps, you're going to have to look at it and again, figure out, okay, what information I'm keeping. There's notices you have to provide applicants, right? To say this is the information we collect. This is how we collect it. This is what we do with it. And then all the way through to the end. So it's going to take a lot of thinking to figure out all of those steps, starting with whether they even have to comply with this law. That's the first step in the process, right? Because a lot of our clients won't even need to comply, but for our larger clients that fall into one of those three categories, they're going to have to go through and sort of revamp their systems and decide, do they need the information they're collecting, and then disclose what they're doing with it to the candidates and to the employees.
Can I add a little bit to that?
Yeah, sorry. Go ahead. Go ahead, Barry.
It's actually sort of heartwarming to hear so it's coming from somebody in HR because with respect to privacy programs, one of the biggest challenges is getting everybody in the organization who has a role in collecting information to participate. And the knowledge that Linda's bringing to the table, combining with HR, is just phenomenal. And we the first step, we absolutely agree with Linda. The first step is first determine if there's likelihood that you're going to be covered by the law, and secondly, we focus on any law because it's one person if you're collecting information from Europe, as an example. But But then the next step we call data mapping, which is exactly what Linda defined, which is understanding whose data you're collecting, what is the process you're using to collect that, where does it get stored, how is it protected, who is it shared with, and all of that tells us things like, okay, for instance, if you're sharing it with any third party, like an HR application, you need a data protection agreement with that vendor at this point. So it expands beyond just the organization itself.
Well, I wanted to just take a step back and look at the new employer obligations and employee rights. This is actually a slide that Linda provided from a previous. I know she's been a guest speaker on a lot of these. Everybody wants to pick her brain about all of this. So can you run us through this, Linda, please?
Yeah, just a few things to point out. So like on the right to know, for example, I don't know of any organizations that are selling their employee data. That's not really something that, I ever run across anyway. Sharing it, to Barry's point, happens all the time, right? So an employee enrolls in the 401k program. Now the 401k provider, a TPA, maybe the platform has personal information, right? Or you enroll them into employee benefits. That's sharing information. So to Barry's point, you have to sort of take a look at the information and where it's going and who's getting access to it one way or the other. So this is part of the disclosure, letting employees know that they have a right to know where their information is going and who has access to it. If the information is incorrect in some way, then they have a right to say, hey, go fix it. Right to delete is really an interesting one, because what if an employee comes to you and they say, you know what, I'm really worried about identity theft. I want you to take my social security number out of the system. Well, guess what? You can't, right? Because you also have an obligation to pay taxes under that social security number. So the right to delete, you're going to also have to have some notices to say, sorry, we're not going to let you do that. And here's why. So you can get on the list here. Really, the right to delete is really the one I think that's going to give people the most heartburn out of all of these. In addition to the right to know and just coming up with the disclosures to begin with.
Right. And I know, Barry, you touched on this a little bit. It's not just the employees. I imagine if you have people who are interviewees, or applicants,
Candidates,
applicants starting, and they say, well, what are you doing with our information? They're going to fall under this, right? Your applicants and
And the other one as well. And that includes people who have left the organization, right? Retired or found a different job. They're also covered.
That's really good to know. So again, going back to your point, Linda, about looking at the whole life cycle, everything, every touch point for people, right?
Right, exactly.
Yeah.
Yeah, it's just, some organizations, like I noticed a friend of mine who's on here today, she's been working in the mortgage industry. So from that standpoint, they've had to comply with that side of things, right? Because they're consumer. They've had to comply with that side of things for 2 years now, right? But now this is the first time they have to sort of shift it over. Everything's going to have a different thought process behind it, right? Because it has to do now with the employee life cycle and not what they're doing with consumer information. So they're going to have to run two different programs sort of at the same time.
So what might be, I know it's really preliminary in the sense that B2B organizations are starting to think about this, but what might they do now to start preparing for CPRA? And when is it? It starts in January.
January 1. Yep.
Yeah.
January 1, but thankfully they said they're not going to enforce it until to July 1. So we'll see. That gives us a little bit of time anyway, but people need to get on board now, not wait till, June 30th.
Yeah. So what
there is also a year look back, by the way, as well, initially.
As what?
A year look back. So, somebody who's left the organization, whatever, he still has, regardless of that, it starts January 1st. So going back to January 1st of 2022, they can ask for that information.
Would there be a requirement to provide former employees with the notices?
No, former employees are not employees, but there should be some way of providing them information about their rights, and you might have to do it publicly as opposed to inside the organization. A separate section of the external privacy notice.
Mm-hmm. Interesting. So, Krista, going back to your question, I think, it's what Barry and I have been talking about is sort of the data mapping, to use this phrase, right, of going through every step in your process, identifying what information you're collecting, how you're collecting it, where you're storing it, who has access to it. And then probably the next step in that is determining, what information that we've already identified is absolutely necessary to keep and others that employees will have the ability to opt out on or right to leave, right? Because there's going to be instances. And I honestly believe that employees aren't going to all rush in and say, hey, delete all of this stuff. I don't think that's going to happen. I think this is probably going to be a lot more burdensome than in the setup and everything rather than in maintaining it going forward. If that makes sense. I don't think this is going to become a huge issue for employees, but you have to be smart about it and you have to figure out, okay, what can we do and what, should we do? Like, I'll give you an example that I was thinking about this the other day. So some employers maintain copies of responsive documents to the form I-9, right? When employees come on board, right? It's the form that you fill out saying that you're eligible to work in the United States. And some employers will keep copies of the responsive documents. So that would fall under what's personal sensitive information. So a passport maybe, or they could use a driver's license and a social security card, right? So that is information that's necessary to complete the document, right? But it's not necessary to keep it per se. But that may be your practice. Like we keep a copy of it and we either physically attach it to a hard copy or we upload it into a payroll system, however you're completing the I-9s. But if an employee came forward and say, you know what, I want you to delete that copy of my passport, I think you'd probably be obligated to do so because it's not necessary to maintain the copy of the document, right? Maintain the Form I-9 with the information, but not the attachment. So I think you're going to have to really be very detailed and very specific about that analysis to say, okay, we have to keep the number of the passport, but we don't necessarily have to keep a copy of the passport. And then people to request that one be deleted and tell them no on the other one. That makes
a little bit more to that. One is the history of employees being covered by privacy laws exists in GDPR, which went into effect in May of 2018. And what many organizations in Europe have found is that employees don't exercise their rights except when they're disgruntled. And when they're disgruntled, they have a right to have an agent make requests for them because that's part of CCPA. And sometimes that's an attorney. And the challenge is that an organization that has disgruntled employees has to treat this as if it's an e-discovery request, a no-cost e-discovery request without any additional law requirement or any additional legal action. So there's an issue associated for employee data associated with right to know. The second thing that I would add is that what you're saying, Lynn, is really important. Each one of these privacy laws now has a requirement for what's called data minimization, which is a phenomenal thing for an organization to do. Get rid of data you don't need because it has significant value to the organization. No one can ask for data you don't have. And you can't lose data you don't have. It can't be breached. So significant value to the organization that you say, okay, let's walk through this process. Let's figure out what you have and where it's located. The other piece that I add is that while many application systems have databases behind them, and certainly HR systems do, a lot of HR processes use unstructured data. They store data in file systems. They store data in OneDrive or Google Drive or Dropbox or whatever. That's all fair game for requests for right to know, right to delete, and so forth. So understanding the processes that include semi-automated processes are really important. And as much as possible, you want to think through those processes and understand, do you really want to store data in those locations? May not be a good idea.
Barry, let me ask you a question. So one of the things I was reading about is how emails that are sent to and from are covered by this. So how does personal information and emails come into play with one another?
There's two answers to that. One is that an email sent to an employee to the employee that is not business related is considered personal information. So anybody who's been using their company email box as a personal email box may include emails from friends, which is considered personal information. The second part of it is that anything that's in email that is business oriented. I mean, it could be a discussion about an employee that is related to their annual review or something like that. That's included in what it could be covered by right to know or right to delete.
So I can feel people in the audience, their heads are starting to explode with all of this information, and we're just scratching the surface. But we did talk a little bit, Barry and Linda, about California isn't going to come and specifically look for you. Can we just kind of help people feel a little bit better about this, that this is something that they actually can tackle and doesn't have to be perfect tomorrow?
So let me answer that question from personal questions I've asked. Right? We sit right between attorneys, privacy attorneys, and helping organizations implement this and work with everybody in the organization to do this. And I've been asking these questions for years about what do employers need to deal with? And the answer has been consistent from the very beginning. The first answer is there's no attorney general or now the California Privacy Protection Agency or a supervisory authority in Europe that is out to get any business. That's not their goal. Their goal is to ensure that businesses are fundamentally being upstanding citizens. They're working their program. They've implemented a program. They understand, they've defined the steps they're going to take. They're walking down that path, implementing those steps. And it doesn't guarantee that you're compliant, but it does give the supervisory authority a view that we're not interested in heavily penalizing you if we find that there's an issue. Mm-hmm. So working the program is really what it's all about. And it can't be superficial. Just putting a privacy notice on your website is not sufficient. You actually have to have a plan for what you're doing, and you have to be able to demonstrate that you're doing that. And that's why the governance components of this, the accountability components of it, and tracking that you've done the data mapping, and you can prove to an agency that you're doing that, and you're implementing appropriate security controls, as you'll discuss next in the next session, Krista, is all part of what you have to be able to show.
Right.
Krista, it looks like we have a hand raised from Naya.
Yes.
Naya, if you have a question, you can put it in the chat, or you can put it in the Q&A, or I think you can unmute yourself.
Yeah, go ahead and unmute, Naya, and you can ask your question. Thank you, Jeff. I'm going to allow you to talk. There we go. Naya, you can unmute yourself. Do you have a question?
There we go.
There you go.
No, we can't hear you though.
Oh, I don't have any questions. Thank you, though.
Oh, okay.
Oh, your hand's raised.
Your hand was up.
Oh, really?
Yeah, you were just giving us a high five, like, yeah, this is good.
I love the information. That's why.
We were so excited if somebody had a question. So
I know. All right. Well, thank you.
Naya's actually my friend that has been working in mortgage. So been dealing with this on the other side.
That's great. Jeff, do we have any other questions?
Look here.
Can I add one before the questions come up that
Sure.
It has me a bit concerned. That is, there's a new definition in CPRA called sensitive personal information.
Mm-hmm.
And sensitive personal information is the things that you would expect: driver's license, social security numbers, state IDs, passport numbers, and so forth. It also includes genetic and biometric data. That's like thumbprints or face recognition to get access to offices, these kinds of things. Racial and ethnic origins, religious and sexual orientation, and so forth. But two of those that are of particular interest to the employees, I think. One is precise geolocation information. If you have any tracking that is being done on vehicles that our employees are driving, that becomes sensitive personal information, and you need to start by ensuring that you're getting consent to do that to protect the organization. The second is, and we talked about contents of emails, text messages, emails, and physical mail are considered sensitive personal information. And what's most significant about sensitive personal information, you're allowed to use it, as Linda said. There's business purpose for some of this. You need driver's license. You may need social security numbers and so forth. And you don't have to justify that. It's an appropriate business purpose, and it's to be expected by the employee. You have to define the purposes. That's one of the other things you have to do associated with data mapping, is define, I'm collecting this data and this is the purpose. And you have to document that purpose in the notice to employees or to consumers, to the public privacy notice. If you use it for some other purpose than what you have documented, for information, employees now have the right to say, limit the use of my sensitive personal information. Don't use it for things that were not defined. And if you decide you're going to do it, you actually have to get consent at that point. You actually do that. This is one of the places where there's two places where consent is now part of California privacy law. One has to do with under 16 years old, individuals under 16 years old, as well as use of personal information that is not predefined as part of the known purpose that you've outlined to employees.
The geolocation is interesting. When many years ago, when I worked in another sales organization, they would want to be able to track where you are when you were out, on your calls and whatnot. So are you saying that now that comes under privacy? Because that's interesting. I'm curious.
Sensitive personal information in privacy.
Yeah. That is something to think about.
Well,
go on.
Let me throw in a bonus tidbit for all of you. So there's another new law going into effect in California that's actually part of the vehicle code, but it's going to be enforced by the labor commissioner. And that is, if you do have a situation, like Barry said, or in Krista, where people are being monitored via GPS, like on fleet vehicles or, commercial vehicles, you now have to allow the employee to turn that off when they're not working. So you car home, right? I monitor where you are during the day, but you're allowed to take the car home and use it. I can't monitor you when you're off duty. So that GPS has to be disabled.
Yeah. Wow. There's a lot of business use cases, I think, that we can go through, and we're coming up. We're actually at a little bit after 9:30. So we can continue this conversation, I think, for a long, long time. Like I said, we're just getting started. I'm going to go ahead and share my screen again. So just give me a moment. There we go. You guys can see it. Looks like we don't have a lot of questions, Jeff, because I think we're at the end of our time here. So your next steps, obviously, are to begin to think about this and to devise a plan. You can contact Consilien. We do have a complimentary discovery session where we can talk about maybe your particular business use case. We can invite Barry. We can invite Linda to that discovery session as well, if needed. So you'll get an email with the recording, so you can share this information within your organization and start thinking about how you're going to begin to apply it. And then please save the date for January 6th, 2023, where we have Diana Ikatani and then Eric Kong talking about the security implications. And then I think we're going to get more into what Barry and Linda have already kind of touched on with an attorney. So this is your team, data privacy, security, HR, and your attorney. So anyway, thank you so much for joining us. Thank you, Barry. Thank you, Linda. Thank you, Jeff. And thank you, everyone who joined. This was really informative. I appreciate your time.
Thank you,
Good to
Krista.
be here. Thank you.